All right, today we're diving into a very specific and pretty fascinating corner of the legal world. We're talking about a kind of last resort, a special key for when a powerful decision has been made against you. This is Rule 64 of the Rules of Court, and it's all about how you can challenge what seems, well, unchallengeable.
So just imagine this for a second. There's this incredibly powerful constitutional body, right? And it issues a final ruling. Maybe it's about an election, maybe a huge government audit. You're on the losing end of that decision, and then you find out there's no normal way to appeal it. The door seems shut. So, what do you do now?
See, we're not talking about just any government agency here. We're zeroing in on two very specific, very powerful bodies, the Commission on Elections, or COMELEC, and the Commission on Audit, COA. Their final rulings are meant to be just that, final. That whole ladder of appeals you might be used to, it just doesn't apply here. It really does look like a dead end. But is it? Not quite.
And this is exactly where our special key comes into play, Rule 64. This rule was literally created for this exact situation. Now, this isn't some secret backdoor or a loophole. It's a very specific official remedy designed to crack open a path for review when pretty much every other door has been slammed shut.
And what's so interesting here is just how precise Rule 64 is. It's not a sledgehammer, it's more like a scalpel. It only applies to final orders from COMELEC and COA. That's it. And what's really crucial is that it only applies when these commissions are acting like a court, in their adjudicatory or quasi-judicial capacity, where they're deciding the rights of specific people or groups. It has nothing to do with their bigger, broader rulemaking powers.
Okay, and this next point is absolutely critical to understand. Rule 64 is not an appeal. An appeal would let you re-argue the whole case, look at the evidence again. This isn't that. Instead, it uses a completely different legal tool called a petition for certiorari. So think of it this way. You're not asking for a do-over. You're asking a higher court to check if the commission even had the proper authority to make the decision it did. And that distinction, it changes everything.
Which leads to the obvious question, right? If you can't re-argue the facts of the case, if you can't ask a higher court for a different opinion on the evidence, then what's the point? What can you actually challenge with this special key? Well, this gets right to the very heart of what certiorari is all about.
And here it is, the critical difference. You can't use Rule 64 to argue that the commission just got it wrong. That's what's called an error of judgment. You can't say, hey, they interpreted the law incorrectly or they didn't weigh the evidence right. The only thing you can challenge is what's called grave abuse of discretion. You have to prove that the commission acted completely outside of its legal authority, or that its decision was so random, so arbitrary, that it was basically just unfair.
And hey, don't just take my word for it. The Supreme Court laid this out perfectly in the case of Rena versus the Commission on Audit. This quote makes it crystal clear. Certiorari isn't for fixing simple mistakes. It is a powerful, focused tool that is only supposed to be used for fixing major breakdowns in jurisdiction.
So, let's say you believe you meet the high bar for this petition. But, knowing you can file is one thing. Actually doing it correctly is a whole other challenge. The process is incredibly strict, and believe me, the clock starts ticking the second that decision comes down.
If there is one number you need to burn into your brain when it comes to Rule 64, it's this one right here, 30. Not 60, not 90, just 30.
You get exactly 30 days. That's it. 30 days from the moment you're notified of the commission's final order or from when they deny your motion for reconsideration. And here's the real kicker. That 30-day period is absolute. It is non-extendable. You miss it by an hour and you're done. There are no second chances.
And just to put that in perspective for you, a standard petition for certiorari, which falls under Rule 65, usually gives you 60 days. Rule 64 literally cuts that time in half, and the Supreme Court, in the case of Loken versus COMELEC, made it really clear that while the remedy is similar, the timelines are intentionally different, and a whole lot stricter when you're dealing with these two specific commissions.
So, as you can see, the path is direct, but it is incredibly steep. Once your motion for reconsideration gets denied, your one and only shot is to file that petition directly with the Supreme Court, and you have to do it all within that super tight 30-day window.
So, you did it. You beat the clock. You filed your petition with the Supreme Court. You can finally relax, right? Well, not so fast. There are a couple more really crucial and honestly, often surprising hurdles you still need to clear.
Okay, this is a big one. This is something that catches a lot of people off guard. Just because you filed a petition,
that does not automatically put the Commission's original order on hold. While your case is sitting with the Supreme Court, the Commission can still move forward and enforce its decision against you. So if you actually want to hit the pause button on that original ruling, you have to take another separate step. You have to specifically ask the Supreme Court to issue what's called a temporary restraining order, a TRO, or a writ of preliminary injunction. If you don't get one of those, that original ruling from the Commission, it stays in full force and effect.
So let's just put it all together real quick. This summary really shows just how specialized Rule 64 is. It's only for final orders from COMELEC and COA. The method is a petition for certiorari, filed directly with the Supreme Court. The only ground you can use is grave abuse of discretion. You have a strict, non-negotiable 30-day deadline, and filing doesn't automatically stop the judgment from being carried out.
So why does a rule this strict and this narrow even exist? Well, it really comes down to a balancing act. On one side, you need powerful, independent commissions like COMELEC and COA to be able to do their jobs effectively without having every single one of their decisions tied up in endless appeals. But on the other side, you absolutely need a safeguard against them potentially overreaching their power. And the real question is, does this rule strike the right balance? That's the incredibly fine line that Rule 64 walks. Thanks for joining us for this explainer.